Welcome to another episode of The Dissection. It's not raining or even pouring for General Shadrack Sibiya. He is caught in a Mkwanazi hailstorm with no umbrella, no shoes, and wet socks. The courts have sent him packing because his arguments were lacking. Even one of the sharpest advocates in the game could not untangle that Sibiya spaghetti. The courts were like, no, stay at home. Listen, Shadrack Sibiya has been trying to get recourse in the courts to get back to work, potentially to get his hands back on those dockets, and he's also been in the courts or trying to get the courts to make General Mkwanazi retract the statements that he made about him. But these legal efforts have failed spectacularly and dismally for him. Yesterday, the court delivered a scathing judgment against him and basically told him to stop behaving like ChatGPT. In effect, they told him, stop hallucinating. And they ruled against him and added a cost order for good measure. So, I actually don't know where Shadrack Sibiya has been getting money to run around the courts. And maybe, top cops get top dollar. I don't know. But he's been getting all of these lawyers, all of these advocates, sending letters, doing all of these things. The whole thing reminds me of when Jabulani Khumalo was running around the courts trying to get back his position as leader of the Mkhonto Wesizwe party. He thought he was going to gwaza his way back, but the system gwazed him away. And those dreams have dried up. They live only on Biz News, which still sometimes gives him platform to hallucinate like ChatGPT and remember his days when he was leading the MK party. Well, in all of that, at least he managed to get a Toyota Land Cruiser and a Mercedes-Benz truck and, a Biz News recurring slot every now and again. This all reminds me of that. So when we go back to Sibiya, at some point, it looked like he was going to go to court for defamation against General Mkwanazi. His lawyers sent a letter to General Mkwanazi asking for a retraction, a public apology, but it looks as if he's let that dream go because Mkwanazi ain't apologizing for nothing. The way he came on the 6th of July, you could tell this is a man who's committed to see this through to the end. He ain't apologizing for anything. And in fact, truth is a defense in defamation cases. And if Mkwanazi had gone to that court and started, adducing the evidence that he had, that actually could have been more damaging for General Sibiya if that evidence is existent and valid. So it looks like he's dropped that one. It looks like that litigation ambition has been put to the side. He moved on one line of court action. He went to the Gauteng courts and he tried to get his job back. And what he tried to do was to get back into the office. But this was something which was negated on two levels, right? Even before the judgment had landed, it was something that had already been negated within the policing side. It looks like they don't want that man near any police work. And I doubt he'll ever go back to the office, actually. So how do they negate this? Number one, we know that the dockets which were on his desk were moved to KwaZulu-Natal. The controversial, contentious dockets, they were already moved. He was going to find his desk empty. And number two, he was also issued with an intention to suspend him. So now, not only was he dealing with the issue of the special leave, he was now dealing with the fact that even before he went to the court, he had already been given a notice of suspension. Effectively, this meant that even if he succeeded in the court, he would not find the dockets on his desk and he would not have any space whatsoever to get back to his office because the suspension process was underway. But let's talk about what happened in the court and what the court said. It's quite interesting, quite revealing actually. His argument in the court was that the special leave he was put on was not lawful and was not compliant with the procedure. So what he was seeking from the court was that they set aside that particular decision to put him on special suspension and also other stuff. In fact, even before he got to the arguments, remember he said, 1 judge ain't enough for me. 2 judge ain't enough for me. So they gave him the big 3. And that big 3 gave him a massive repudiation. They legally smacked him in the face. So this was what he was asking the court to declare. Number one, he was asking for this, that the second respondent, which is the police commissioner, the first respondent was the South African Police Service. He was asking that the second respondent's decision to direct the applicant to stay at home pending an investigation be declared as unlawful, void, of no force or effect, and to be reviewed and set aside, and the status quo ex ante be restored. So put me back where I was on the 31st of December or thereabouts. Number two, that pending the conclusion of a judicial commission of inquiry announced by the fourth respondent, being the president, on the 13th of July 2025, the second respondent be interdicted from instituting parallel proceedings and action against Sibiya, which includes inter alia, suspending, investigating, or disciplining the applicant in relation to the allegations made by the South African Police Service, KZN Provincial Commissioner General Mkhwanazi, and any other matters which may form part of the terms of reference and mandate of the above-mentioned Judicial Commission of Inquiry. So he was relying heavily on the argument that the commission should be the only entity that examines him, that we must all wait for the commission to finish, and at that point, that's the only time he can now have any proceedings that relate to suspending, investigating, disciplining. This was called taking a chance, illegally taking a chance. So he didn't want anything to be done to him, right? Regarding the interim interdict and why no disciplinary steps should be taken against the applicant pending finalization of the commission's report, the applicant stated that the commissioner's purported decision to initiate an investigation against him is also unlawful because it obstructs and undermines the work of the commission. He makes the statement because he said the decision to investigate him was made by the commissioner in response to the same allegations that the president relied on to establish the commission. This was his argument. So here's some smolanyana relevant background that you need to be aware of to keep up with everything. So when the police commissioner went on annual leave in the festive season from the 31st of December to the 13th of January, that's when Police Minister Senzo Mchunu moved. That decision in and of itself is dubious. It's questionable. I hope that he gets asked more about it, because the decision, the timing thereof, you wait for the commissioner to go on leave, then you announce this decision. So that's what happened. And the argumentation was that the Minister of Police had observed that the further existence of the team was no longer required, nor was it adding value to policing in South Africa. And then his directive called for the disbandment or the disestablishment of the task team. Up to now, that argument makes no sense. We've just seen the killing of another liquidator, following the killing of Cloet Murray and his son, following the killings of multiple auditors in municipalities, not least the Ekurhuleni municipality. An auditor went there, extensive experience. Within 3 months of being in that job, they had assassinated him. The fact that this minister was able to say, or then minister, or, semi-suspended minister of police, we still don't know whether he's ever coming back, but he's on this leave where he gets all the perks, all the payments. In any case, the argument is still not logical or rational to this day, because the reality confounds what he asserted. Now, Sibiya then had a meeting with the commissioner when he came back. And the argument Sibiya was making to the commissioner is that he wanted a disbandment in the style of the Scorpions. He wanted an immediate disbandment. And when the commissioner asked him for a plan, he drafted one which was more directly towards quick disbandment. Give me the dockets. But then the police commissioner said, no, I'm not happy with that. He drafted his own plan that was for a more gradual disbandment. They tried to show that plan to the minister. The minister was not available. They were missing him. They ended up giving it to the chief of staff. They only were able to present it to the minister on the 6th of March, the day after Mkhwanazi made those presentations in parliament. So as all of that was happening, Sibiya disregarded the instructions that he was given by the commissioner. And he went rogue. Those are my words, but he went rogue. So here's what the court said. The commissioner's position is that it came to his attention that, contrary to his direct instructions of 14 January 2025, the applicant, Sibiya, proceeded to give directives and instructions to the task team to immediately hand over dockets to the head office. In support of this contention, the commissioner annexed letters given under the hand of the applicant on 17 January 2025, 4 February 2025, and 22 April 2025. So Sibiya was trying to get these dockets. He was trying to make sure that the task team was not operational. Then at paragraph 48 of the judgment, it says the following. Upon making inquiries, it then appeared to the commissioner that the applicant might have deliberately ignored my instructions and acted contrary to his obligations in terms of his appointment, which necessitated an investigation as to his intentions and motives and interest. Intentions, motives, interest in the disbandment of the task team. Why you want it so much? Why does it tickle you so much that there's a task team? Why is it under your skin? That's what the police commissioner was wondering. So, can I just make a side comment here that I've never heard of a police officer praising the disbandment of the Scorpions. That was an effective team. It was an effective team. And it's rather odd. It's rather odd for that to be something that he would use as an example of effective administrative action. Think about it. Everybody praises the Scorpions, especially in law enforcement. Why would he then be the one to come through and start questioning that? And start even motivating for an example such as the disbanding of the Scorpions. Can I also add that the whole fight that he's been on to get back to work has really been amusing to me. I've never seen anybody so eager to go back to work. Work is work at the end of the day, no matter how you slice it, no matter what kind of cheese they're giving you, whether they're giving you blue cheese, whether they're giving you sriracha sauce, whether you get to eat, chicken nuggets and donuts and whatever else, whether you get ngutus every night. Work is work. Work is work. Who realistically would deny going on paid leave if you're being investigated for something where you're innocent? It's a great deal. One, I didn't do anything. Two, you're going to pay me. I'm going to take some months off. I can spend time with my family. I can hang out with my friends. I can catch up with some reading. I can watch my Netflix series. I can watch Narcos. I can learn from Pablo Escobar. I can see how they were moving things in Colombia. I can really get into my, Narcos and watch and see. I can watch Jerusalem again, get some inspiration. I have options. Only Sibiya wants to go back to work so desperately. I've never seen anybody so desperate to get back to work. Also, I have a question. His job was Deputy National Commissioner for Crime Detection. Kidnapping went up under him. Vusimuzi Matlala has been implicated in the kidnapping of Jerry Bushoka, for example. Kidnapping was going up. The Commissioner for Crime Detection was not detecting any crime, but he was talking to the people who were doing the kidnappings. They've been going up and up, kidnappings. Think about this. Ever since he got to the appointment, can anyone tell us what crime he actually detected? So much energy to go back to work. To do what exactly? When did you last score a goal there for Bafana Bafana? When were you last critical to the performance of the team? Because every time people mention your name, even in the comments to these videos, they're not saying that you were doing impeccable work, outstanding work, exemplary work, impeccable work. Nah, that's not what they're saying. Anyway, let's go back to the judgment. This is what the court ultimately said in the rejection, emphatic rejection. At paragraph 64, they said the following. The attempts by the applicant's counsel, and this is when they were saying, listen, you were trying, Baba, to the counsel. You tried it, but it didn't work. The attempts by the applicant's counsel to convert or elevate the stay-at-home instruction to a suspension is not supported by evidence. The fact that the discipline regulations does not make provision for such an order does not mean that such an instruction by a senior officer to a subordinate cannot be made. We therefore conclude that the instruction was not unlawful. At paragraph 71, the applicant does not have a right to have disciplinary proceedings halted or suspended. The right which the applicant seeks to assert is a self-constructed right. He claims that everyone implicated by the allegations which form the subject matter of the commission have a right to a free and fair hearing before the commission. The above assertion misconstrues the nature of the commission. Although the commission may, at the conclusion of its investigation, make recommendations to the president regarding disciplinary steps and the continuation of employer-employee relations, the commission is neither a court nor of itself a disciplinary tribunal. Neither a court nor of itself a disciplinary tribunal. It's another in and of itself, but coming from the court this time. Witnesses, even though they themselves may be implicated in allegations, may be subpoenaed and have the obligation to appear before the commission. The proceedings before the commission are, however, not hearings in the conventional sense. Then in paragraph 74, and you can go find this judgment, it's a great judgment, I'll put a link in the description. Moreover, the applicant seeks to contend that separate disciplinary proceedings against him for disobeying lawful instructions issued by his superior would not only interfere with the work of the commission, but, on his version, obstruct it. There is no factual basis for this assertion. They're saying it's hallucination of a ChatGPT variation. That's what they're insinuating here. From the evidence already summarized, it is clear that the disciplinary charges, even though they may notionally intersect, to use a term deployed by the applicant's counsel, with the investigation of allegations which form the subject matter of the commission's terms of reference, the parallel process of the envisaged disciplining of the applicant would not affect any other findings which the commission may independently make. And that's what I've been saying the whole time. That's what I've been saying. The whole idea that somehow whatever Mkhwanazi is doing is going to disturb the commission is not true. Whoever's making that argument is not being genuine. And the judges, not one judge, not two judges, 3 judges are saying, strike out. Strike out with that argument. That's what they're saying. That's what they're saying. This is what the court said. Simply put, the disciplining of the applicant and the work of the commission are 2 different things. Even if the applicant's motive for having disobeyed an order may be of interest to the commission. At paragraph 83, there is no evidence of any reasonable apprehension that the applicant would not be able to put forward his version before an independent disciplinary tribunal, and accordingly, the second requirement for an interim interdict has also not been satisfied. There is no evidence that proceeding with any disciplinary proceeding against the applicant would taint any work of the commission. As already indicated, the disciplinary process would in no way hinder or obstruct the work of the commission, and the commission may continue to gather evidence regarding the allegations made by General Mkhwanazi of historical facts or previous interference in police investigations. Dismissed with costs. Dismissed with costs. Dismissed with costs. This is a major L for General Sibiya, and he has to hold this L. He has to digest this L. He has to make sure it's assimilated into his body, because it's a major L. It's been running around the courts, and now the courts are saying, Baba, take your suspension and eat it. The other issue that is now awaiting judgment, because the courts have been used as the other forum, is the bail application for Vusimuzi Matlala, which deserves an episode all of its own. The man is trying to get back on the streets, and in my opinion, that's the worst thing that could happen for the commission, for witnesses and potential witnesses. Listen, if something is going to taint the commission, is this homie being out on the streets. Because we know that the AK-47s, which have been murking everybody, this homie's AK-47s have a higher body count than King Von, Lil Durk, and all these other people. That man, wherever he's been implicated, there are rivers of blood that are flowing. He seems to be the operations manager for all of the hits that have been occurring in Gauteng for the Hoshkari fathers. The Hoshkari behavior has an enforcer, and Vusimuzi Matlala is one of those people. So he's applying for bail, he's trying to get out, but if he gets out, if anything could taint the commission, it's him, this guy. If any of these allegations are true, and by all evidence that has currently been reported on by the media, those pieces of evidence seem to indicate that everything that has been said about this guy is bona fide. It's true. By the way, the reason why those dockets are causing panic is not because of Vusi Matlala. He's a small boy in the game. He's the enforcer in the main, who also started, doing a side hustle and getting into the tender game. The biggest tender that he tried to get was that 360 million. That would have taken him to another level. That would have elevated him, right? He would have been a made man at that particular point in their cartel. But he's a small boy in the game. There are much bigger fish in this ocean. And this is perhaps why you shouldn't get bail, this guy. Because there are much bigger fish in the ocean. And the fact that already we know that ministers' names are showing up, former minister Pegitele, former current on leave minister, special leave minister Senzo Mkhunu, the fact that we're already talking about ministers' names should give some clues to all of us about how high this actually goes. And there's one name that the media has not been looking into much, and it's not the big guy, but it's a significant name. They've not drawn any lines that connect to the big guy in the spiderweb thingies, and they've also stopped drawing any spiderweb thingies about this man. That one name. That name should have been mentioned by now. It's not Brown Mkhotsi, it's not Malcolm X, the local version, it's not Katiso Molefe, it's not Vusi Matlala, and it's not Shadrack Sibiya, it's not Senzo Mkhunu. I'll explain more in my next episode. Stay tuned. That name is Hangwani Morgan Maumela. He could be at the center of all of this, and it deserves an episode all of its own. So stay tuned for the next one. Meet you in the comments.